Thank the gentlelady from Indiana. I now recognize the ranking member of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Ms. Perryman, while Congress sets broad policies, we cannot possibly craft the myriad of technical and detailed rules necessary to carry out those policies. It would be reckless for us to believe otherwise. That's why we write laws with the expectation that agencies are staffed with subject matter experts who can ensure that our laws have the effects we intend. How would overturning Chevron affect our efforts to combat climate change? Use your mic.
Thank you, Mr. Ranking Member of the committee. I think it could be devastating. As you've noted, there is significant subject matter expertise within our federal agencies. Congress has the legislative power and does pass laws, but those laws have to be implemented, and Congress cannot start to implement every single law that it passes. And so overturning Chevron, I think, will be significant with respect to climate, but also with respect to healthcare, with respect to so many other essential government functions. There have been a number of scholars and researchers that have warned about the broad sweeping implications of something like this.
And how about corner posts with respect to climate change?
Corner post presents a particular concern, just as you highlighted. If the Supreme Court were to adopt the petitioner's argument in corner post, what you could have is a potential avalanche of litigation over long-standing rules and regulations that have been on the books for many years, that are that have been on the books for many years. That could really unleash a lot of regulatory instability, as well as problems for addressing the urgent needs that this Congress has asked the agencies to address.
And same question, how would overturning Chevron affect our efforts to ensure clean water and air for our communities?
And it's roughly the same answer. There are a number of policies that Congress has passed in order to ensure clean water and clean air, but those have to be implemented by our federal agencies. They implement and work on those policies every day. Overturning, replacing that agency expertise with the views of generalist judges is very concerning to both the integrity of the policies that Congress seeks to have implemented, as well as to the health and well-being of the American people.
Same question on corner post.
I'm going to give you the same answer.
Okay.
I mean, the real concern with corner post, of course, is that you have a number of rules and regulations, policies that are doing the work for the people that have been on the books for so long, and upending the statute of limitations, where any litigant can come in and seek to engage in judicial manipulation by trying to challenge longstanding rules that have already been litigated and found to be lawful. That's very concerning.
Thank you. I'm hearing lots of contradictions from the majority's witnesses. ALJs are not sufficiently independent, and yet the FTC diminished the role of ALJs to lessen their importance. ALJs are not independent enough, so we should allow them to be fireable at will. Finally, from the majority's witness statements, it appears that they are in favor of an Article III trial for every TSA pre-check application. I cannot imagine the burden on our courts. Ms. Perryman, a poor outcome in the Jarkissi case would mean that endless cases from the public will be pushed from expert administrative law judges onto the already overburdened federal courts. What would the delay in these cases mean for litigants?
I think the delays would be significant, as would the delay for people who are seeking to be protected by the laws that agencies are implementing. I would also just note that in the Jarkissi case, of course, and you mentioned this contradiction, but the same interests that are seeking to undermine ALJs overall, or saying that they're not independent enough, are also seeking to undermine the removal protections for them, which is something the American Bar Association, as well as a number of institutions, have supported in order to make sure that ALJs function in that quasi role with impartiality.
True. How many Article III judges would we need to appoint to the federal bench to account for these cases?
I don't have a precise number, but you are familiar, I'm sure, with a report that came out of Thomson Reuters and some others on the overburdened nature of our Article III courts. And so I think you would have a significant number of additional Article III judges that would need to be appointed.
If we got rid of ALJs, would you say we might have to appoint 600 new Article III judges?
We would definitely have to appoint a significant amount.
More than 100, several hundred?
I would think so.
I wonder then how many judges the chair would like President Biden to appoint to ensure that these cases are heard in a timely fashion. Mr. Chairman, I yield back.